Yes.
My lady, my lords, I appear with Miss Sandra Healy on behalf of the claimant insurers. The claim is for the return or recovery of $22 million paid as insurance proceeds in respect of the loss of the ship insured under a policy issued by my clients. And that ship, which my clients now allege, and the court in separate proceedings has held, was procured by the owner's willful misconduct. My learned friends, Mr. Stephen Berry QC and Mr. Adam Board, appear on behalf of the bank, who was the mortgagee of the vessel and a loss payee and assignee of the insurance policy in question, and who received the vast majority of the insurance proceeds. There are 4 issues which the court will be asked to decide, all of which are concerned with the existence and extent of the court's jurisdiction to hear and determine the insurer's claims under the Brussels regulation recast. The Court of Appeal, like Mr. Justice Tier below, held that the court has jurisdiction in respect of the insurer's claims for damages for misrepresentation, but not in respect of the insurer's claims for restitution. The object of each claim, the recovery of $22 million, is the same. The difference lies in the underlying cause of action. My lady, my lords, the 4 issues in question are succinctly set out in the Statement of Issues and Facts, which I'm happy to take the court to. It's at the bundle CV, core volume 1, tab 5, page 153.
Can I ask, is there any practical reason why it matters whether this case is litigated in England or the Netherlands?
Well, then you'll have to ask each of the parties, but from our perspective, we say that the English law governs the cause of action in whatever jurisdiction the matter is litigated. And so to that extent, it may not. But we say that the English court is better suited to apply English law in those circumstances rather than the court in the Netherlands.
Dutch courts are applying English law all the time.
They do, they are. But one of the considerations when considering issues of forum convenience, my lady, is whether the law being applied to the dispute is being applied by a home court or by a foreign court.
Yes, but that's not this case.
It's not this case. But I'm answering my Lord's question as to the practical difference. And that's one difference which has been identified.
But simply that an English court would be more familiar with English law?
Yes. But the question could be posed to either side. Because we're at a juncture, my lord, where we've got 2 causes of action. The court has held that one cause of action to be litigated here and the other not. And it's the same object of the claim, which is $22 million. But it would require a modification of either party to agree to one jurisdiction. And without that modification, I'm afraid, my lady, my lords, this issue will have to be determined by this court. But if I could revert back to the Statement of Issues and Facts, which you'll see at paragraph 42. I hope I gave you the page reference. If I haven't, I can give it to you.
You have given it to us.
That's very kind, my lady. The 4 issues are, does the court have jurisdiction pursuant to the English jurisdiction clause contained in the policy? That's issue 1. And I should make it clear, that's the issue on which my clients appeal. There's issue 2, which is, are the insurer's claims against the bank matters relating to insurance, which is the insurance section of the Brussels regulation recast. And that's issue number 2, and that arises as a respondent's point to the bank's appeal. And issue number 3 is, if the answer to issue 2 is yes, is the bank entitled to rely on the insurance section by virtue of it falling within a class of persons who are entitled to the protection afforded by that section? And that's issue 3, and that's the subject matter of the bank's appeal. And then finally, issue 4, are the insurer's claims for restitution matters relating to tort delict or quasi-delict under Article 7, sub-Article 2 of the Brussels regulation recast? That's issue number 4, and that's the subject matter of my client's appeal. And of course, in relation to that particular issue, my clients will be inviting this court to overturn the decision of the House of Lords in Kleinmort-Benson to the extent that it's inconsistent with the case being put forward to this court. Now, my lady and my lords, the consequences of a determination of each of these issues is set out on the next page of the Statement of Facts and Issues, paragraphs 46 and 47. I don't propose to go through that, but the court will see what will happen depending upon the determination of each of the issues.
Can I ask, in relation to the second, third, and fourth issues,
Yes.
they're all issues of EU law. Have the parties given consideration to whether the court will be in a position to make a preliminary reference if this country leaves the EU before we have given judgment?
I haven't discussed that expressly with my learned friend. The law, as I understand it, is if the United Kingdom leaves the EU, then the court is no longer in a position to make a preliminary reference after that date, even if the court is seized of the matter. And by contrast, the court is still in a position to apply the Brussels regulation recast, even afterwards, so long as the court was seized of the matter. So that's where we are.
And is the position on preliminary references affected by the current, most recent withdrawal agreement?
That I don't know.
But this is what we need to know.
Well, the current state...
I am amazed that you come with issues of EU law, which are presented at the highest level. So under the current situation, we are obliged to make a reference if the matter isn't act declare. There is a substantial, I'm not going to say risk, probability that before this court is in a position to give judgment, we shall have left the European Union. And therefore, it's all going to depend upon whether we leave with or without a deal and what the consequences of the deal will be. By deal, I mean withdrawal agreement and the withdrawal bill. Now, no doubt we can go away and look it up for ourselves, but actually, mostly, Council don't want us to do that because they're afraid we might get it wrong.
No, I would not suggest you decide anything along those lines without input from Council. All I can tell you at the moment is, as the law stands, the court is not in position to make that reference after the United Kingdom leaves the EU. Of course, there is a draft withdrawal agreement, but it's not yet the law of the land.
Is it only a draft?
No, it isn't a draft.
Well, in the sense that it's not been passed by Parliament.
No, but it's not a
it's
draft.
It's a national agreement, isn't it?
It's a treaty.
It is, but there's an act of Parliament which says that the court can't make a reference until that, it seems to me that act of Parliament has to be modified or insofar as it deals with the references.
Well, the withdrawal agreement bill will also have handled this.
Perhaps, but
The fact that it is not currently being presented to Parliament doesn't alter the fact.
Maybe, perhaps the most efficient way of dealing with this is something I and my learned friend can look at overnight, and we can report back to you tomorrow.
Thank you.
I'm sorry if I should have offered that immediately, but the consequences of the determination, as I say, is set out in the Statement of Issues. The insurers the issues number 1 and 4 will be argued today, and issues number 2 and 3 will be argued tomorrow. So with that introduction, I propose to launch straight into issue number 1. Of course, if any member of the court has a question, I'm happy to answer it now or during the course of the hearing.
We've asked the 2 questions that are right at the top of our minds.
Okay. So the issue number 1 is the question of whether or not jurisdiction can be essentially determined in accordance with the jurisdiction agreement in the insurance policy. And my lady and my lords, that jurisdiction agreement can be found in bundle CV2. Tab number 7. Sub-tab J. And if the court turns to page 370, you'll see the first...
I'm sorry, what's the electronic...
Oh, I beg your pardon. 370 is the first page
Thank you.
of
370.
of the contract of insurance, just so you can see where we are. And if you proceed to 374, so you can, at the top of the page it says choice of law and jurisdiction. This insurance shall be governed by and construed in accordance with the law of England and Wales, and each party agrees to submit to the exclusive jurisdiction of the courts of England and Wales. Now, the question before the court is whether or not this is a jurisdiction agreement which essentially binds the bank in the context of this dispute. There is no issue as to the scope of the jurisdiction agreement, and of course, there's no issue that as between the contracting parties to the policy, that this jurisdiction agreement would be given effect under the Brussels regulation recast, either under Article 25 or under Article 15 and 16, to the extent that the insurance section applies. Before considering the submissions, however, one has to note the nature of the bank's interest in this particular policy. And for this purpose, if we could stay with the same bundle, and it is, I'm sorry, no, it's, beg your pardon. Yes, same bundle, it's, I'm sorry. So if you go to, there should be another bundle called Appendix Part 2. And it's the electronic page, there are 3 tabs to look at, but if we just go to the first tab, which is tab 5, and the electronic page number is 2002.
Sorry, say that again, please.
2002, my lord. Could you just look up? I expect it was. No, I've got it there. And this is a deed of assignment, and there are 2 other deeds in the succeeding tabs. And all that the court needs to see, it seems to me, is at page 2006. There is an assignment at clause 3 at the bottom of the page, and it's an assignment by the owner of the vessel to the bank, who's identified as the assignee, of all the owner's right, title, and interest, present and future, in and to the assigned property. And the assigned property is identified at page 2005, so the preceding page. And at the top of the page, there's the reference to assigned property, which means the insurances, the earnings, and the requisition compensation. And it's the insurances we're concerned about. And the insurances are defined on the same page, about 2/3 down the page. It says insurances means all policies and contracts of insurance, which are taken out in relation to the vessel.
Is this a statutory assignment?
At the very least, it's an equitable assignment. There was a dispute between my learned friend and myself at the first hearing before Mr. Justice Tier as to whether it was a legal assignment as well. And to be a legal assignment, it could be a legal assignment under Section 136 or of the Law of Property Act, or under Section 50 of the Marine Insurance Act of 1906. But I don't think it matters either way, because the title of the bank as an assignee, whether equitable or legal, is essentially the same. Yes. And then that's the assignment. Now that assignment was notified, and I'm sorry to take you back to the policy. It's back to CV2, tab 7, sub-tab J, and it's page 403. And there's a notice of assignment which is endorsed to the policy. So notification has been given to the insurers that the owners have assigned the policy to Credit Europe Bank. And on the next page, 404, is a loss payable clause. Essentially, this is a clause which entitles the bank to be paid the insurance proceeds in the event of a loss. There's a reference to the assignment in the first paragraph, and in the second paragraph, it states claims payable under this policy in respect of a total or constructive total or an arranged or agreed or compromised total loss or unrepaired damage, and all claims which in the opinion of the mortgagee are analogous thereto shall be payable to the mortgagee up to the mortgagee's mortgage interest. So basically in the context of this case, there was a total loss, and the bank was therefore a loss payee, therefore entitled to payment. And as a loss payee, would be entitled to enforce that promise under the Contracts, Rights of Third Parties Act of 1999. So that's the factual background to the bank's interest. Now, the bank is not a party to the insurance policy. It's not an original party. Its interest lies as an assignee and as a loss payee, and its interest was noted in the policy in both respects, and also as mortgagee of the vessel. Third parties are bound, and it's my submission, are bound by the jurisdiction agreement where there is a succession or transfer of rights or obligations under national law, here English law, provided there is consent between the original contracting parties. And the original contracting parties were the insurers and the owners. Now, to make this point good, I would ask the court to look at the decision of the European Court in Girling, and for that purpose, it's it's the other authorities bundle, number 3, tab 65.
Could you give us the MS?
Yes. So it's the first page is 1768, but I'm going to take.
Sorry, you'll have to say that more clearly.
I'm so sorry. The first page is 1768.
1768.
But I'm going to take the court directly to 1779. Now, this was a case where the Italian ministry had succeeded to certain rights under insurance policies against insurers. And the question being posed to the European Court is identified at paragraph 10, where reference is made to the court being asked basically to clarify whether the convention, and in particular Article 17 thereof, and in today's regulation that's Article 25, may be interpreted as meaning that under a contract of insurance, a person in whose favour the contract is made, but who is not a party to the contract, and who is separate from the insured, is entitled to rely on a clause extending jurisdiction inserted for his benefit, although he has not himself signed it, albeit the insurer and insured have duly done so. And then if we could proceed to the next page at 1780, paragraph 19 at the bottom of the page. Consequently, if the requirement is to form referred to in Article 17 were to be regarded as requiring the insured or beneficiary not being a party to the contract, but a person for whose benefit the clause conferring a jurisdiction is made expressly to sign the said clause so as to validate it and to entitle him to rely on it, the effect of such an interpretation would be to place on the latter, in view of the fact that originally the insurer has unequivocally given his consent to an open and general system of extension of jurisdiction, a pointless restriction amounting, even it may be, to a formality with which it would be difficult to comply if before any proceedings the insured has not been informed by the policyholder of the existence of a clause conferring jurisdiction which has been made for his benefit. And then next paragraph. it follows from all the foregoing that the answer should be that where in a contract of insurance, a clause conferring jurisdiction is inserted for the benefit of the insured, who is not a party to the contract, but a person distinct from the policyholder, it must be regarded as valid within the meaning of Article 17 of the Convention, provided that, as between the insurer and the policyholder, the condition as to writing laid down therein has been satisfied, and provided that the consent of the insurer in that respect has been clearly and precisely manifested.
So are you treating issue 1 as an issue of EU law?
Yes, so as far as jurisdiction agreements is concerned, to be given effect under the regulation, there is a requirement of consensus for the jurisdiction agreement. Now, what the European Court is saying is that consensus is to be established according to European Court principles only as between the original contracting parties. But as far as the third party is concerned, that can be dealt with as a matter of national law. And so the question is the third party's rights subject to the jurisdiction agreement? Now, I'm going to develop the submission as I proceed. I hope, my Lord, that answers my Lord's question.
Well, it's surely a question of national law.
It is.
Yes, that's what I thought.
Yes.
I was wondering why we were looking at an ECJ judgment.
Just to establish the fact that, just to make good the point that it is a matter of national law. Now, there's another decision which I will refer to, which is another European Court decision, but I'll do it in the context of referring to academic opinion, because my client's position is this, that as a third party, whether as a signee or as a loss payee with rights under the 99 Act, insofar as the bank asserts rights under the policy, it must do so subject to observing the requirements of the English jurisdiction agreement included in the policy. And this is the principle sometimes referred to as the conditional benefit principle. And it's perhaps best stated by Mr. Joseph QC in his book on jurisdiction agreements and arbitration agreements. And for that, if we could turn to Primary Authorities Bundle number 2, PA2. Tab 38. It's page 1160, 1160. And under the heading, Mr. Joseph, under the heading Article 25 of the Brussels Regulation Recast, says at paragraph 7.19, where the original parties to a maritime transport contract have concluded a jurisdiction agreement that complies with the requirements of Article 25 of the Brussels Regulation Recast, or the Lugano II Convention, then as third party who, as a matter of the relevant governing national law, succeeds to the rights and obligations of one of the original parties, will be obliged and entitled to bring proceedings in accordance with its terms. It is not necessary to show that the third party has consented to, accepted, or was even aware of the choice of court agreement. The validity is assessed by reference to the relationship between the original contracting parties and the effect of the assignment under national law. There is no distinction between the position under the Brussels Regulation Recast and the Lugano Convention. Then if we could skip 720 and proceed to 721 on page 1162. Thus, the jurisprudence from the Court of Justice in this area, binding successors without more to the original party's jurisdiction agreement, should probably now be seen as restricted to maritime transport contracts and the particular concepts developed thereunder of the statutory transfer of the rights and obligations under bills of lading. The statutory transfer of rights and obligations under bills of lading is not on all fours with assignment, since the obligations under a contract not are transferred by assignment. At common law, however, an assignee of contractual rights takes an assignment of
Is that a misprint?
It must be. It's not on forward assignment since the obligations under a contract are not, rather than not are. At common law, however, an assignee of contractual rights takes an assignment of rights subject to any equities, including the obligation to enforce assigned rights consistently with the terms of the original contract, including a choice of court agreement. Now, in the course of its judgment in the Tilly-Russ, the Court of Justice put the matter as follows. Now, I will read this out unless the court wishes to read it itself, but I'm in your hands. Paragraph 24, insofar as the jurisdiction clause incorporated in the Bill of Lading is valid under Article 17.
You don't need to read it all
Okay.
out.
Well, I think that's...
You wish that we read it now?
Please, if you could read it yourselves.
Yes.
Then paragraph 723 on page 1163. The inability of an assignee to have conferred upon him greater rights than possessed by the assignor is a central part of the conditional benefit analysis referred to above and is echoed in the reasoning of the Court of Justice in the Tilly-Russ. Therefore, it's suggested that in the case of an assignment of a right, which as a matter of English law is subjected to the obligation to bring proceedings in a chosen forum, the right can only be enforced or asserted subject to the choice of forum obligation. And there is no requirement under Article 25 of the Brussels I regulation recast for any further consent to be demonstrated by either the debtor or the assignee. There is strong support for this conclusion in the judgment of Lord Justice Sheeman in Furswood against Petrobank and followed by Mr. Justice Moore-Bick in Glencore against Metro. The effect, proceeding to the next paragraph, the effect of an assignment of contractual rights in the context of an Article 25 agreement, however, depends upon both national and community law. First, the effect of the assignment is analysed as a matter of national law. If under the governing law of the assigned contract, an assignee is not subject to the obligation to litigate disputes in the designated forum without specific assent, then it seems that the assignment of rights will not be effective to create an Article 25 agreement as between the debtor and the assignee without specific consent. And then I'll skip the next sentence and then proceed to the next paragraph. So far in the analysis, the position of the assignee bringing proceedings against the debtor has been considered. If, however, proceedings were brought against the assignee by the debtor, for example, by way of a declaration of non-liability, then the view of Mr. Justice Moore-Bick in Glencore and Metro was that the assignee could still insist on being sued in the country of his domicile because the assignee is not a party to the jurisdiction agreement. Just pausing there, my lady, my lords, I will come to Mr. Justice Moore-Bick's decision in a moment. It is suggested, however, that this is not the position with regard to statutory transfer and ought not to be the position with regard to claims against an assignee either. A claim to enforce the benefit and a claim for a declaration for non-liability is the same cause of action for the purposes of the Brussels I regulation recast. The assignee's right in respect to the contractual benefit, whether determined in proceedings brought by the debtor for a negative declaration or in proceedings at the suit of the assignee, should be ascertained consistently with the jurisdiction agreement. Therefore, if the debtor commenced proceedings against the assignee for a negative declaration relying upon the choice of court agreement, it is suggested that the assignee would not be entitled to have those proceedings stayed in favour of the courts of his domicile because the debtor would be entitled to plead the agreement against the assignee. The assignee ought not to be entitled to assert its rights in court in a manner inconsistent with the terms of the jurisdiction agreement. Equally, where an assignor has the benefit of a contractual right only to be sued in the courts of a particular jurisdiction and then assigns the benefit of this contract, then the assignee will stand in the shoes of the assignor and should be entitled to enforce the right only to be sued in that designated court. And now, of course, Mr. Joseph was confining himself to questions of assignment there, and as a matter of national law, and by reference to further authorities I'll take the court to, it is clear that where assignee sues, that it does so and must do so in accordance with the jurisdiction agreement in the relevant contract. So this is not one of those cases where national law doesn't subject the assignee to the jurisdiction agreement.
Obviously you're going to come to this, but the problem, our case is you're having to go a good deal further than a declaration of a negative declaration, because in your case is that there's been a settlement agreement, an agreement settling a claim. You say that agreement is liable to be set aside because it was entered into under a mistake or as a result of a misrepresentation. And that there's then, on its being set aside, you then have a restitutionary claim to repayment. So your claim is actually based on a different contract, it relates to a different contract from the insurance policy.
It is, although, as I stated earlier, my lord, there's no dispute as to the scope of the jurisdiction agreement in the policy, because jurisdiction agreements have now been construed by this court and by the courts below as being construed in favour of a one-stop adjudication. And so we would say the jurisdiction agreement is wide enough to encompass any claims for payment under the policy, but also for the recovery of payments made under the policy. So that's not an issue before this court today. The only issue before this court is whether or not the bank is subject to the jurisdiction agreement in circumstances where it is not suing, but is being sued. And to go back to the negative declaration example, Mr. Joseph, for example, suggests that if the bank was sued by the insurers by virtue of a negative declaration, for example, that a declaration that they're not liable under the policy to indemnify or pay money to the bank, then the bank would be subject to that. And we say, well, the position really shouldn't be much different if the bank has asserted rights to payment under the policy. Those and payment has been made in answer to that assertion. And given the new information which has arisen since then, the insurers now see themselves as having been the victim of a misrepresentation or a mistake, and therefore are entitled to recover those proceeds. Now, there should be no difference if the bank has to sue for those proceeds under the policy, or if the bank demands the proceeds, they are paid, and then they're sought to be recovered.
The negative declaration finding that you refer to, it seems to be backed up by a European case, is that right? But the issue is one of national law.
It is.
Yes, and if all that can be transferred under an assignment is a right and not an obligation, why does a negative declaration impose an obligation on the assignee to submit to the jurisdiction of the person asserting the right to the negative declaration?
Well, I think the answer comes in two parts. The first part is that the very nature of the conditional benefit principle is if one asserts an entitlement to a benefit, for example, payment under the policy, even if that doesn't require, even if there's no suit by that party asserting the right, then that right must be subject to any conditions which attach to the right in particular. Yeah. And one of the conditions is, of course, the choice of law and jurisdiction agreement. That's the first answer. The second answer is when it comes to issues of, as Mr. Joseph said, is when it comes to issues of negative declarations and claims made under for payment, they're basically the two sides of the same coin. They're the one cause of action which arises.
Yes, but I appreciate that. But yes. I mean, there may be two sides of the same coin, but one involves the assertion by the person seeking the negative declaration, while the other involves the assertion by the assignee who is subject to the conditional benefit doctrine.
Yes.
So doesn't this two sides of the coin concept ignore the fact that an assignation does not transfer obligation?
Well, I think the answer to that, my lord, is this, that of course, if the assignee asserts no rights whatsoever, subject to the negative declaration principle, then it may be said that there is no obligation upon the bank to comply with the jurisdiction agreement. However, in circumstances where the bank takes the step of asserting rights under the policy. So it doesn't have to, it can pause, it can consider its position, yes. But here, on our submission, and there's a separate issue between my learned friend and myself as to this, but where the bank has has asserted a right to payment under the policy, or to direct how payment should be made, then it must be subject to the obligation.
Yes, well, there's two issues as I understand it. What one is whether the assertion of the right requires litigation.
Yes.
And if it doesn't, the issue is, does the letter of authorization amount to an
Correct.
assertion of right?
Correct.
I appreciate that, but at the moment I don't see why, just because the negative declaration is the other side of the coin, I don't see why that can impose an obligation on the person against whom the negative declaration is asserted to submit to the jurisdiction, given that assignments don't transfer obligations.
Well, of course, that's not our case in this case. I appreciate. I know.
No, but you're citing this as an authority.
I am. Well, it's in a more extreme position than our case, because in a negative declaration case, there is no assertion of right. So there may be no assertion of right by the bank or by the assignee in those circumstances. Of course, there may be, and that leads the insurers to proceed with a negative declaration. But if the third-party assignee has been utterly silent,
Yes.
and the insurers then take it upon themselves to commence negative declaration proceedings, that's a more extreme example than our case, because we say there is an assertion of a right.
No,
But
well, you don't depend on this passage for your answer.
No, but except that the passage does adopt the position as in relation to a more extreme position, and we say it's.
And I'm trying to see what the justification for it is at the moment.
Well, I think it's this. It would be a very odd state of affairs if an assignee could sue under a contract for a benefit and thereby be subject to a jurisdiction agreement. But if the other party who would owe the obligation sues for a negative declaration, that same party saying we're not liable, then it seems likely that it must be governed by the choice of law and jurisdiction agreement, only because it's very likely that the person, the assignee, will counterclaim for a benefit under the policy, or not. But in those circumstances, it would be an odd state of affairs that the jurisdiction agreement applies in one case but not the other. But as I say, we're not in that territory.
Okay, thank you.
Yeah. And just to, I won't take my lady and my lords to this, but Professor Briggs adopts a similar position as Mr. Joseph when it comes to the Contracts, Rights of Third Parties Act, 1999. I can take you to it if you think would help.
Well, just give us the reference.
Of course, it's paragraph 2.1. Sorry, it's Primary Authority Bundle 2, tab 36, and it's pages 1141, and it's the last paragraph of paragraph 2-135.
No doubt we'll come back to this, but at the moment, first let you know, the difficulty I'm having with this is that it seems to me the policy is essentially a matter of history. There's a contract between the parties. There's an issue about whether there's a contract between the parties, but your case is that there was a settlement agreement compromising a claim, and that agreement becomes the measure of the parties' rights. And you say that agreement was entered into in circumstances which vitiated it, because it was either a mistake or a misrepresentation. And as a consequence, it can be set aside, and you're entitled to the money that was paid under that agreement. Now, that's all rather remote from the original insurance policy.
Well, I'm going to quote your lordship on that when I could deal with issue number 2, which concerns matters relating to insurance. But the fact is that the courts below have held that there's no good arguable case that the bank was a party to the settlement agreement. So as far as the bank is concerned, there is no settlement agreement. It's only a settlement agreement with the owners. So there is, in that particular instance, we have the bank who has, we say, demanded or asserted rights under the policy, and when we come to the letter of authority, I'll take you to it, but it has indicated firstly that the monies should be paid to the broker, and upon doing so that the insurer's obligations are discharged. And so that as far as the bank and the insurers are concerned, that letter of authority is a demand under the policy, we say. And what we're seeking is recovery of those proceeds paid in accordance with that letter of authority. Now, that letter of authority must relate to the policy. It can't relate to the settlement agreement. It's been appended to the settlement agreement, but because the bank has been said not to be a party to the settlement agreement, then it must relate to the policy. I hope that answers my Lord's question. Or at least halfway answers my Lord's question.
Not quite, it's quite difficult to keep track of the relationships here because there are so many people involved and things are being done in a rather ill-defined way.
It is, yes, I see that. I do see that.
The money is actually paid to Willis, isn't it? By
To the
you.
broker.
You pay it to Willis, Willis pay it on to the bank.
Yes. But that was in accordance with the bank's direction or authority in the letter of authority, whereby they said, upon payment, your obligations are under the policy are discharged. And it was done in their capacity as lost payee. I've given the court reference to Professor Briggs's paragraph, and so what I say here is that there is a transfer of rights under the policy to the bank, either as an assignee or a lost payee or both, and that includes a transfer of the condition attaching to such rights, which is the observance of the English jurisdiction agreement. Now, the real issue between my learned friend and myself is this, and I think my learned friend will correct me if I'm wrong, I'm sure, but I think my learned friend accepts that if the bank had commenced proceedings against the insurers, then that would be subject to the jurisdiction agreement. So the real question is an assertion of rights, which is not amounting to commenced proceedings, sufficient to attract the jurisdiction agreement in these circumstances? And it seems to be common ground that there is an exclusive jurisdiction agreement in the policy. The bank is an assignee and a lost payee with third-party rights. The bank received the bulk of the policy proceeds. And as I say, if the bank commenced proceedings, it would have to do so in accordance with the jurisdiction agreement. And therefore, as I say, the issue is between the parties is whether the bank is similarly bound, where it claims or asserts an entitlement to payment. The policy proceeds are paid in accordance with or in answer to that assertion. A dispute later emerges between the insurers and the bank as to the bank's entitlement to the funds, and the insurers sue the bank for the return of the proceeds. Sorry.
But you pay the money to Willis under an agreement to which the bank is not party. Willis, in turn, pay the money on to the bank. And when we talk about the money, we're not talking about sacks of coins, but,
No, it's electronic transfer.
but an electronic transfer. And you're not asserting a proprietary right to anything. But you're saying that the setting aside of your agreement with Willis, to which the bank wasn't party, entitles you to the restitution of the money which Willis paid to the bank.
Well, our principal claim, my Lord, is for damages for misrepresentation, because we say there were a number of representations made which led to the
Yes,
settlement.
but your appeal concerns a restitution claim.
Absolutely right. And the restitutionary claim is made, there are two aspects to it. One is it's a restitutionary claim based on mistaken payment, because
Mistaken payment to Willis.
on behalf, but it was in accordance with the authority given by the bank to pay Willis. So that was, so when I come to the letter of authority, the bank says, please pay Willis, and upon doing so, your obligations are discharged. Now, as far as, now we say that, as I said, the condition attaching to the benefit in this particular case, the assertion of rights, is the observance of the jurisdiction agreement. I think it's fair to say that none of the authorities, English authorities, which are before the court, or indeed the European authorities, deal with this particular issue. Most of the authorities are really concerned with a factual scenario where proceedings have been commenced in breach, if you like, of the relevant jurisdiction or arbitration agreement. However, there are comments which I will take your, my lady and my lords to. But we say, firstly, it comes down to a matter of principle. As I say, it's common ground that a party in the position of the bank would be bound by the jurisdiction agreement if the bank sued. So why should the position be different if the bank claims or asserts an entitlement to the proceeds and the insurers then pay, but the insurers then subsequently demand the return of the funds on the grounds that there was no original entitlement to those proceeds? There is no conceivable reason why the position should be different. The bank was intending to assert and rely on its rights under the policy, whether or not it was intending to sue.
But I mean, isn't there a difference? Because in the one case, the bank is seeking to ask the court to exercise its jurisdiction in its favour, and in the other case, not.
The mere fact that the bank is the claimant, that's true, but I would say that's not, with respect, my lord, it's not a meaningful distinction, because what we're really concerned about is the attachment of observing the choice of law and the choice of jurisdiction agreement upon rights which have been transferred to the bank, whether under the 99 Act or by way of assignment, and where there's an assertion of those rights. So it seems a matter of happenstance if the insurers refused to pay in accordance with that assertion and then had to be sued by the bank, actually chose to pay, but then subsequently discovered they actually had a defence and therefore the money should be repaid. So it seems to me it's be an odd state of affairs if the application of the jurisdiction agreement should depend upon that happenstance.
Yes, thank you.
Well, it may be a fundamental difference. In a former situation, rights under the policy are being asserted. In these proceedings, I'm not sure that's the case.
Well, that's the factual question as to whether the letter of authority amounts to an assertion of a right. I think, my lord, that's the point my lord is making, I think.
No.
Oh, sorry, I misunderstood. I'm so sorry.
Well, I mean, this is a restitutionary claim brought on the basis of the setting aside of a settlement agreement for mistake or misrepresentation. I'm not sure that involves any assertion of a right under the policy by the bank.
What, no, so the original, the claim for restitution is reacting to an assertion of rights, which was then acted upon by payment.
Yes, well, it's the point I made earlier, but it's sort of background history,
Yes.
but I'm not sure it's the subject matter of the current proceedings. But I don't want to take up time with it. I've made my position clear.
Well, and I just want to clarify one other point, my lord. My lord has, I think, a couple of times referred to the fact this is a claim for relation to restitution, which is right, and that's the subject matter of my appeal. But of course, it's also a respondent's point to my learned friend's appeal, in the sense that my learned friend is seeking to obtain a ruling from this court that there is no jurisdiction in relation to the damages claim.
Yes, well, that's perhaps...
And it applies to both.
Well, so it's really the same... Well, it's for him to make his argument, but it's really a very similar point.
Yes, it is.
You know, that a claim for damages for misrepresentation is very different from the assertion of rights under the insurance.
Well, not if those assertion of rights themselves are presented with a representation which is alleged to be, by us, to be a misrepresentation. I don't think they are that far apart. They are connected. And again, as far as the restitutionary claim is concerned, we're speaking in terms of a mistake in payment, and that mistake is, again, responding to an assertion of rights under the policy. And what we say is that this is entirely in accordance with the terms of the jurisdiction agreement. Each party, original parties, agreed to submit to the exclusive jurisdiction of the courts of England and Wales, and it doesn't say that the jurisdiction agreement applies only in the event that one party or another sues. And what we say is it really does matter is what the assertion of right, not the commencement of suit. And that's, I say, the principal dispute before this court. For the jurisdiction agreement to apply to the bank, is it enough merely to assert any rights under the policy, or must they go further and commence suit? And of course, the courts below have held so far that there must be a commencement of suit. So we say it boils down to being a question of principle, and the jurisdiction agreement really does apply to any dispute arising under the policy, whether the bank sues the insurers for payment, whether the insurers sue the bank for repayment, or more extreme example, where the bank sues the bank for negative declaratory relief. Now, the position can be compared with Section 8 of the Arbitration Act of 1996, which applies to arbitration agreements, not jurisdiction agreements. And for this purpose, I'd ask the court to refer to Primary Authorities Bundle 1, PA1, tab 11. And if the first page of the report is 731, and it's a decision of Mr. Justice Coleman in the Commercial Court in a case called Nishin Shipping against Cleves and Company. And I don't know how it's coming up on the screen, but I think it's probably more helpful we turn to page 733. And now this is a claim made by a third-party shipbroker for commission promised by the charterers under a charter party with a shipowner. And Section 8 of the Arbitration Act is set out at paragraph 9 on page 733. And it's probably just worth referring to Section 1, which states, subsection 1, subject to the provisions of this Act, a person who is not a party to a contract, a third party, may in his own right enforce a term of the contract in certain circumstances, which you see in A and B. And subparagraph 4 says this section does not confer a right on a third party to enforce a term of a contract otherwise than subject to and in accordance with any other relevant terms of the contract. And then Section 8 provides that where a right under Section 1 to enforce a term is subject to a term providing for the submission of disputes to arbitration, and B, the arbitration agreement is an agreement in writing for the purposes of Part 1 of the Arbitration Act, the third party shall be treated for the purposes of that Act as a party to the arbitration agreement as regards dispute between himself and the promissor relating to the enforcement of the substantive term by the third party. Now, what we say is Sections 1 and 8 basically are statutory recognition of this conditioned benefit principle, which applies to, in this case, arbitration agreements. And this reflects, as we'll see from Justice Coleman's decision, the common law position in relation to the conditional benefit principle. The reason Section 8 is required is because Section 8 is making it clear that the Arbitration Act of 1996 applies to third parties in these circumstances. And then if we could proceed to page 738. Oh, sorry, actually 737, I'm so sorry. 737. Now, paragraphs 35 and 36, I won't read it to you, it's just for your reference, but there's a reference to the parliamentary notes which were prepared by the Lord Chancellor's Department explaining the Act. And on the second column, paragraph 34 of these notes, there's a reference to Section 8 of the Arbitration Act. And paragraph 34, the notes say subsection 1 deals with what is likely to be the most common situation. The third party's substantive right, for example, to payment by the promisor, is conferred subject to disputes being referred to arbitration. This section is based on a conditional benefit approach. It ensures that a third party who wishes to take action to enforce his substantive right is not only able to enforce effectively his right to arbitrate, but is also bound to enforce his right by arbitration. So that, for example, a stay of proceedings can be ordered up against him under Section 9. This approach is analogous to that applied to assignees who may be prevented from unconscionably taking a substantive benefit free of its procedural burden. And then there's a reference to Lord Justice Hobhouse's decision in the J. Bowler. And the quote is, disputes relating to the enforcement of the substantive term by the third party is intended to have a wide ambit and to include disputes between the third party who wishes to enforce the term and the promisor as to the validity, interpretation, existence, or performance of the term, the third party's entitlement to enforce the term, the jurisdiction of the arbitral tribunal, or the recognition and enforcement of an arbitration award. But to avoid imposing a pure burden on the third party, it does not cover, for example, a separate dispute in relation to a tort claim by the promisor against the third party for damages. Now, if we go to the next page at 738, you'll see reference to the J. Bowler at paragraph 38, and then there's an earlier decision of Mr. Justice Hobhouse in the Jordan-Nikolaev, which is referred to in paragraph 39, and I'm just taking you to the quote from that judgment at the bottom of the first column. Where the assignment is the assignment of the cause of action, it will, in the absence of some agreement to the contrary, include, as stated in section 136, all the remedies in respect of that cause of action. The relevant remedy is the right to arbitrate and obtain an arbitration award in respect of the cause of action. The assignees are bound by the arbitration clause in the sense that it cannot assert the assigned right without also accepting the obligation to arbitrate. Accordingly, it is clear, both from the statute and from a consideration of the position of the assignee, that the assignee has the benefit of the arbitration clause as well as the other provisions of the contract. And then Mr. Justice Coleman then goes on, basically applies the conditional benefit principle. Now, if you turn to page 739, at paragraph 47 and 48, Mr. Justice Coleman refers to an article written by Ms. Claire Ambrose, which I will take you to. Now, Mr. Justice Coleman disagrees with one of the conclusions made by Ms. Ambrose, but it's not in this context. It's in relation to a different context as to the scope of the arbitration agreement. And what I propose to do now, if I may, is to take you to that article by Ms. Ambrose, which is at Primary Authorities Bundle 2.
On the way there, I mean, when you were quoting from the parliamentary materials which were set out in paragraph 36 of the Mission Shipping Judgment,
Yes.
they were clearly speaking about taking action to enforce substantive rights and also dealing with disputes. So those passages seem to envisage some sort of litigation. Although in the Jordan Nikolaev case, you have a mere speaking of merely asserting a right.
Yes, and I think it's fair to say that Lord Justice Hobhouse, when in J. Bowler, refers back to his own decision in the Jordan Nikolaev and quotes this paragraph as well. But it's absolutely right to say, my lord, that the notes refer to possible enforcement. But what the general conditional benefit principle is concerned with, which was the subject of Lord Justice Hobhouse's decision, was, we say, goes further and refers to the assertion of rights. Now, unless my lady or my lords have any further questions about that, I'm proposed to go to the article prepared by Ms. Ambrose, which is at tab PA2, Primary Authorities 2, tab 35. And it's pages 1128 and 1129, 1128. And it's under the heading Jurisdictional Issues. and it's concerned with Section 8 of the Arbitration Act, of the 99 Act, which applies to arbitration agreements. And it's the second paragraph on the page. More difficulty will arise where the third party had not commenced proceedings in arbitration or court to enforce rights conferred by the contract and has not voluntarily submitted to arbitration. For example, a construction contract gives a third-party subcontractor the right to use the owner's facilities on site free of charge and contains an arbitration agreement requiring all disputes with the subcontractor to be referred to arbitration. The subcontractor makes full use of the facilities, but the owner invoices him for the cost incurred. The subcontractor fails to pay and the owner commences arbitration against him, claiming the cost of the facilities and obtains a default award. And B, an insurance contract expressly confers indemnity on a third party and provides that all disputes be referred to arbitration. The third party makes a claim under the insurance contract and the insurers obtain a declaration of non-liability from an arbitrator. In these cases, the third party could contest the jurisdiction of the tribunal on the grounds that he should not be treated as a party to the arbitration agreement because the dispute did not relate to enforcement of the substantive term by him within the meaning of Section 8.1. However, it appears likely that the third party would be bound by the arbitrator's award in either situation, even though he has neither agreed to arbitrate nor participate in the arbitration. It's assumed he was given but refused an opportunity to participate. In the construction case, it could be said that the third party had already enforced the substantive term, and then proceeding to page 1129, and there's a dispute as to whether he was entitled to do so. In the insurance case, the dispute relates to whether the third party was entitled to claim an indemnity. The third party would be treated as bound by the award because it determines a dispute between himself, the third party, and the promisor relating to the enforcement of the substantive term by the third party. The courts usually favour a broad approach as to whether a dispute falls within an arbitration agreement in order to give effect to the party's presumed intention of one-stop adjudication. The provision disputes relating to enforcement of the substantive term by the third party is intended to have a wide ambit and to include a large variety of disputes. On this basis, it might be argued that a dispute would relate to enforcement of the term by the third party if liability depended on some way on whether the third party could enforce that term. This would, however, probably be too wide an interpretation. Where a third party has never agreed to arbitrate and is only deemed to be a party to the arbitration clause in respect of certain disputes, the court should be less willing to refer the dispute to arbitration. The court may consider that a third party should only be treated as a party to the arbitration agreement under Section 1 if he actively enforces the substantive term. The question then arises to what enforcement by the third party means. It's unlikely that Section 8.1 is limited to situations where the third party enforces the term by proceedings in court or arbitration. Section 1 of the 99 Act confers rights on the third party to enforce a term of the contract, and it cannot have been intended to oblige the third party to litigate in order to rely on such rights. Such a narrow construction would also be contrary to the wider purpose of Section 8.1, which was to bind the third party to arbitrate if he takes the benefit of the contract. Accordingly, it will probably cover situations such as the examples above, that's in A and B on the previous page, where the third party has taken steps to enforce the substantive terms. These sorts of situations probably represent the outer limits of the application of Section 8.1 and fall close to the Law Commission's fear that binding a third party to arbitrate would be contrary to its central philosophy that a contract should not impose burdens on third parties. So we would adopt the reasoning set out by Ms. Ambrose in this context.
But that reasoning seems to be dependent on statutory construction of Sections 1 and Section 8. It doesn't really address the difficulty that an assignee does not receive obligations under the assigned contract.
Well, to this extent, though, Section 1, I think, reflects the conditional benefit principle, my lord. And insofar as the conditional benefit principle is to be said to relate to enforcement of the right, the enforcement, we would suggest, doesn't have to be by litigation. It can be by mere assertion.
Thank you.
Now, of course, if we're wrong about this, there are practical consequences, we say, because that means the insurers would have to sue the owners in one jurisdiction, which is England, because there's a jurisdiction agreement in play, both in the policy but also in the settlement agreement. But the bank in another jurisdiction, and yet the subject matter of the dispute is the same. Factual subject matter of the dispute is the same. And indeed, if the insurers sued the bank in another jurisdiction, wherever that jurisdiction might be, the bank would have been entitled to object on the grounds of the jurisdiction agreement in the policy. Now, with that in mind, I've just asked to take you to a number of other authorities which touch on this issue. The first one is in Primary Authorities Bundle number 1. And it's tab number 14. That's page 781. The first page of the report is 767. And this was a case where insurers were sued by a third party subject to a right of direct action in the courts of Louisiana. And the relevant policy had an English jurisdiction agreement, not an arbitration agreement, a jurisdiction agreement. And the conditional benefit principle arose for consideration by Mr. Justice Aikens, as he then was. And it's paragraph 58 on page 781. Mr. Justice Aikens said that the position in the present case is that World Tanker has asserted a claim on the H&M policies by virtue of the direct action statute in the direct action claim. It is true that World Tanker have not become a party to the policies by a mechanism of statutory innovation or a statutory assignment. But in my view, the nature of the rights that the direct action statute confers on World Tanker is contractual. It confers a statutory right to make a claim on a contract to which World Tanker was not originally a party. And subject to paragraph C of the statute, moving to the next page, the rights are confined to the terms and limits of the policy. Then in paragraph 59, if the statutory claim by World Tanker is based on the H&M...
If you're going to read out all of these sideline passages, would it be quicker and easier for us to read them to ourselves?
I'm very happy for that.
How far do you want us to read?
To the end of paragraph 59.
Thank you.
Well, he's just recounting an argument, isn't he? Does he resolve it?
He does, and he accepts it. But the key point here is what Mr. Justice Aikens is referring to is the reliance on contractual terms. And there's another decision, again in this same bundle, tab 1. I'm sorry if I'm rushing too fast, please say so. It's a decision of Sarah Cockrell QC, sitting as a Deputy High Court Judge, in a case called the Flag EV. So tab 1 of this bundle, page 566. And it's concerned with rights under the Bill of Lading. And one of the points which Ms. Cockrell QC says, paragraph 40 of 566, and this is her conclusion, is that owners have a contractual right for any claims arising out of or in connection with the bills of lading to be resolved in London arbitration and subject to English law. 2, Al Hilal's, who is a third party, right of suit against the owners under the bills is a contingent benefit. It follows it cannot be enforced by demanding delivery of the goods and or advancing a claim under the bills of lading without recognising owners' rights to have any disputes arising arbitrated in London. So there, the learned deputy judge was considering that the assertion of a right to delivery or making a claim would have to be subject to the arbitration agreement. So it didn't require suit, either in arbitration or court.
Managed to track down in the last case, in paragraph 58, we were told that the nature of the rights that the direct action statute confers on World Tanker is contractual. That's apparently a statute forming part of the law of Louisiana.
It is, but the way the courts approached it, my lord, is to consider what the nature of the third party's rights are. And the rights can arise either by assignment, by a third party right of action, for example, as arises under the 99 Act in this case, or under a direct action statute. But what the key point that Mr. Justice Aikens makes is he identifies the right of action as contractual in nature. And that one of the considerations which the Court of Appeal has indicated is that when considering these third-party rights, particularly where they arise under foreign laws, one has to consider whether it's contractual in nature or not. And that's the key finding. And then, sorry, if I go back to the flag EV, subparagraph 3, Ms. Cockrell QC just makes the additional point that the insurers who act as subrogated insurers, so they're outside parties as well, would have to take those rights subject to the obligation to resolve the disputes arising from them in accordance with the arbitration agreements. Now, we say in these circumstances that there is no reason in principle, and indeed the suggested statements of principle by Lord Justice Hobhouse, for example, Mr. Justice Aikens, doesn't say that it has to be a litigation and enforcement in those terms. A mere reliance on or an assertion of rights is sufficient. And that's also supported by Ms. Ambrose's opinion, and also Ms. Cockrell QC's judgment. And my lady and my lords will perhaps remember when Mr. Joseph addressed this issue, again, he referred to this principle applying not only in cases of enforcement but or assertion. Now, the Court of Appeal, in this case, paragraph 58 of its judgment, said that mere assertion is not sufficient, and we say that is wrong. Now, my lady and my lords, I'm going to then proceed with the next aspect of this part of the issue, which is there, in fact, if I'm right about this, and an assertion of rights is sufficient, is there, in fact, an assertion of rights under the letter of authority? And for that purpose, we would have to look at the letter of authority, which is at Bundles Core Volume 2, so CV2, tab 7, bundle, so tab K, page 417. I could ask the court to read that document.
Yep.
Now, the first point to note is that the letter is addressed to the underwriters. It's signed by the bank. It's presented to the insurers on behalf of the bank, as according to Mr. Justice Tier in his judgment, just for your reference, paragraphs 23 to 24 and paragraph 31. I give you an electronic page number if that helps, which is pages 328 and 330. The letter refers to the loss of the vessel, and there's reference to the vessel, fire explosion, and subsequent sinking. And it's that loss which triggers the right to indemnity under the policy. The letter refers to claims of whatsoever nature arising from the above casualty, and it also refers to the fact that the bank is giving authority to the insurers to pay these sums to the broker, Willis. There are two provisos. There are no amounts due under the policy, and secondly, that the bank is the sole loss payee under the policy. That means it's the only person entitled to payment under the policy. And that upon payment to Willis, then the underwriter's obligations are discharged. You can see that in the second paragraph of the letter. Okay. All right. And in those circumstances, the bank was in those circumstances, we say that is an assertion of rights. Now, Mr. Justice Tier below and also the Court of Appeal essentially stated that well, perhaps it's best to show you. In this, it's bundle CV2, it's the same bundle, tab 7, tab B at paragraph 53, page number 294. This is the Court of Appeal's judgment, but referring to Mr. Justice Tier's decision and quoting it. What Mr. Justice Tier says is the bank does not thereby assert its right to payment under the policy in the sense of demanding that the proceeds of the policy be paid to it or to its order. Rather, the bank recognizes that in certain circumstances where it is the sole loss payee of the policy, the bank is entitled to the proceeds of the policy and informs the Hull underwriters in those circumstances they may pay the proceeds to Willis and that such payment will be regarded as a good discharge of the underwriter's obligations. Now, the difficulty, and with respect to Mr. Justice Tier and of course the Court of Appeal, is that it's very difficult to identify the point of distinction between demanding payment of proceeds to the bank in accordance with its rights under the policy and authorizing payment of proceeds to the broker as loss payee in discharge of the insurer's obligations under the policy. And so we say in this particular respect, the court erred, and that this is clearly an assertion of rights under the policy. It identifies its status as loss payee, identifies the entitlement to payment by virtue of the loss, refers to all the claims, and it requires and authorizes payment to the broker, upon which the insurers have no longer an obligation to the bank. So if I'm right, my lady and my lords, and the mere assertion of rights short of litigation or is sufficient to attract the jurisdiction agreement, we say that the letter of authority achieves that end. And unless there are any further questions, I'm going to proceed to the next issue.
Looks as if you've already been asked.
I think I feel that way. Just a warning. I think I've got a nominal break time at 12:30, but the parties have agreed that I can eat into my reply time, and I suspect I will do that on this occasion. So the issue number 4, so unfortunately it's not issue number 2, it's issue number 4, because that's the subject of my client's appeal, is concerned with the question of restitution. Now this is the issue which gives rise to consideration of the House of Lords judgment in Kleinwort Benson. Now this is an issue which obviously relates only to the claim for restitution, not for misrepresentation. And the question really is, does the claim for restitution come within Article 7, Sub-Article 2 of the Brussels regulation recast? Now, in order to consider this, we need to look at the regulation itself, which is PA1, so Primary Authorities 1, tab 15, page 798. And it's Article 7 at the bottom of the page, under the heading Special Jurisdiction. A person domiciled in a member state may be sued in another member state, then subparagraph 1a, in matters relating to contract, in the courts for the place of performance of the obligation in question. Then we can ignore the rest of the article because it's concerned with special cases. And then Sub-Article 2, which is at the top of the next column, in matters relating to tort, delict, or quasi-delict, in the courts for the place where the harmful event occurred or may occur. Now, there was an issue below as to whether or not there was a harmful event within the jurisdiction in relation to the claim for damages for misrepresentation, and the Court of Appeal held that there was such a harmful event. And I just ask your Lord, my lady and my lords, to remember that when I come back to this issue. Now, these two provisions are to be interpreted in accordance with the autonomous meanings ascribed to them by European law. The relationship between these two provisions has been the subject of a decision by the European Court in Calfellis, which I'll come to, but it has been repeated on numerous occasions since then. And if we look at Calfellis, and I don't propose to take you to each of the European decisions, but I will take you to a few. The first one is PA2, so Primary Authorities 2, tab 27. And you can see it's 956, page 956. Now, this was a claim relating to a number of stock exchange transactions, both spot and futures transactions. And the claims were based on contractual liability, but also for unjust enrichment. And the relevant part of the European Court's judgment, you can see at page 959 and 960. And if I could ask the Court to read paragraphs 14 to 18.
So you want 16 and 17, basically, don't you?
Yes.
Firstly, it's an autonomous meaning, and secondly, it covers everything that isn't contract.
Precisely. Now, the autonomous meaning, my lady, is important because what it means is that each national legal system may characterize a particular non-contractual obligation in a particular way. So in some jurisdictions it may be classified as a tort, in other jurisdictions as a claim for unjust enrichment. And we don't need those sorts of complications when it comes to considering what the application of Article 7.2. All that matters, as the European Court has said, is that so long as it's not a matter relating to a contract and you're seeking to establish liability, then it falls within Article 7.2.
Is this the passage which Lord Gough, Homewood Benson, misinterpreted?
We say yes, but we've also there are subsequent authorities which I'll take your Lord subsequent to the decision of Kleinmort Benson.
This is a formulation which is repeated, isn't it?
It is.
In later cases. Lord Gough referred to the difference between answers 2A and 2B, and he said that, I think, that the effect of 2B was that 2A could not have been as broad as was being suggested to that court on that occasion.
Yes, and I will come back to the Lord Gough decision at the end of my submission on this issue.
A point's been raised about the meaning, the translation in English of liability, when the German equivalent has different connotations.
That's right. And of course, that's why an autonomous concept is important in this context. But the point of principle here is why, if each national legal system classifies these non-contractual obligations in a particular way, and in their own, according to their own jurisprudence, why would claims for unjust enrichment be excluded from Article 7.2? Why would you privilege claims for tort or delict over claims for unjust enrichment in this particular way? There's no sensible reason for that. And the other consideration, which is important, is, and as I'll come to, there is, of course, a choice of law regulation, which is Rome 1 and Rome 2. Rome 1 is concerned with contracts, Rome 2 is concerned with non-contractual obligations. And one of the recitals to those regulations requires consistent interpretation between the jurisdiction regulation, Brussels, and the Rome regulations. And if you look at Rome 2 regulation, it deals with both tort, as we would like to call it, but also unjust enrichment. So in order to really, this entirely supports the notion that the Article 7.2, as interpreted by the European Court, really is intending to cover all non-contractual obligations within Article 7.2. And there's no reason to exclude unjust enrichment from that.
One answer to your first question, rhetorical question, may be that in the case of unjust enrichment, there's no linking factor with a particular jurisdiction strong enough to justify a rule of special jurisdiction.
Well, that's the basis upon Lord Gough's decision. He says, well, when it comes to unjust enrichment, at least as understood, I assume he was speaking in terms of as understood by English lawyers, there's no harmful event in many unjust enrichment cases. Now, in this particular case, that's not a concern for us because we're talking about the payment of $22 million, which the court below has indicated was a harmful event. And the mere fact that we've got two separate causes of action seeking the recovery of that $22 million doesn't change matters. So there is a harmful event. But I think Lord Gough was going too far because many restitutionary claims are compensatory in nature. For example, if I pay my lord or pay someone money in terms which is vitiated by a mistake or misrepresentation and I seek to recover it, I have lost money in the process and I'm seeking to recover it. So it's restitutionary in nature as a cause of action, but it has a compensatory effect because I'm making good the loss which I've suffered. So that is a harmful event without any question.
You need a harmful event for your cause of action in...
Well, I think Article 7.2 locates the obligation, locates the source of jurisdiction to the place of the harmful event. So if my lord sees Article 7.2...
I realise that that's what 7.2 says, but for the purposes of succeeding on your cause of action, do you need to show a harmful event?
Well, in the particular circumstances, I have to show what I'm seeking to recover is monies which my clients have paid to the bank and want to recover those monies. So I may not have to describe it as a harmful event or damage, but it's certainly a harmful event which I'm seeking to right.
Thank you.
Yes, but the claim is based on mistake.
It is, but by virtue of that mistake, my clients are worse off, and the order for restitution would make that loss good.
But Article 7 must be read in the context of the regulation as a whole, and the general rule is Article 4.1, which is domicile. And there is case law, I think, which suggests that derogation from the general rule has to be construed narrowly.
It has to be, but the European Court in Calfellis and subsequently has repeated the interpretation as being all actions which seek to establish the liability of the defendant and which are not related to the contract.
Yes, but at one level, you could take that as being all non-voluntary obligation, the enforcement of all non-voluntary obligations.
But that's restitution. That would include restitution, my lord.
It would include almost everything, wouldn't it?
It would.
I mean, what would be left in Article 4.1?
But there's a choice, isn't there? Article 4.1 is the primary obligation, the primary rule. The special jurisdiction, are they compulsory or are they...
No, it's an additional option.
That's what I thought. So Article 4.1 is your default.
Yes.
And then if you've got a claim relating to contract, it can be in one place. And if you've got a claim relating to tort, delict, or quasi-delict, it can be in another place.
That's correct.
So...
But it's still
a derogation.
It's a derogation, and the case law suggests that derogations of this nature are construed narrowly.
They are, but we have a construction by the European Court, which
Yes, but I still ask the question: if what is left in Article 4.1 as a mandatory rule, if all non-voluntary obligations are caught by Article 7.2? And all contractual obligations are caught by Article 7.1.
My lord, may I respond to your question in this way? if for some reason unjust enrichment was left out of Article 7.2, what's the reasoning behind that? What's the point of it? There's none, I would suggest. There's no reason to, as I say, to privilege tortious claims over claims for unjust enrichment. And that's why I suspect that the European Court reached the decision it did, and it has made this point on a number of occasions.
So every claim for unjust enrichment, one would have to find a harmful event, which you say is the payment, is the fact that you've paid something under mistake.
The harmful event could, if it's mere disgorgement of profits made, for example, then it would be the failure to account for those profits. So that wouldn't, in one sense, it's not compensatory because you haven't suffered a loss, but still you're seeking the recovery of illegally obtained or unauthorizedly obtained profits. Now, the failure, the harmful event in that case, I would suggest, would be the failure to account for those profits. And there's another decision which I just quickly take you to. It's in OA3, tab 66, page 1801.
Beg your pardon, which page?
1801. And I'm not going to ask the court to read it now, but it's paragraphs 15 to 22. But the important point here, and again, just for your reference, it's paragraph 20 where the Calfellis interpretation is repeated. But one of the important points made by the European Court on this occasion was, it's in paragraph 16 on page 1801. And of course, my lord referred earlier to the fact that there is issues of derogation have to be construed restrictively, but there's also a principal interpretation which requires the legal certainty, and we can see this in paragraph 16. It should be borne in mind that the Brussels regulation seeks to unify the rules of conflict of jurisdiction in civil and commercial matters by way of rules of jurisdiction which are highly predictable and accordingly pursues an objective of legal certainty which consists in strengthening the legal protection of persons established in the European Union by enabling the applicant to identify easily the court in which he may sue and the defendant reasonably to foresee before which court he may be sued. Now, I would say that the advantage of my client's construction of Article 7.2, we say in accordance with Calfellis, is that all you have to ask yourself is one question. Is the claim relating to a contract? If it is, it falls within Article 7.1. If it's not, it falls within Article 7.2. That's easy to identify and gives rise to certainty. If you have to asking additional questions by reference to autonomous concepts of European law as to what constitutes a tort, delict, or quasi-delict, as opposed to unjust enrichment, you may get, certainly within the jurisdictions of the European Union, you may get different answers, and that gives rise to confusion. And to avoid that uncertainty, I would say that the literal interpretation, the literal meaning of the Calfellis interpretation must be given effect. Now, if I could take you to Professor Briggs, again, it's PA2, tab 36, page 1142. Now, I don't want to read out in the entirety of this paragraph.
No, and you're very short of time.
I am.
So tell us what you'd like us to
So
read.
I would like you to read this paragraph. When I say paragraph, I mean...
You mean 2.172?
I do. But the points to note are these, that one of the reasons, basically Professor Briggs accepts that claims for unjust enrichment should fall within Article 7.2. And one of the reasons he does so, he adopts the position ought to be consistent with the Rome I and Rome II regulation distinction. You can see that in the second paragraph. And I suppose we can pick it up on page 1143. It's the final paragraph which makes the point that if there is a claim for unjust enrichment, insofar as it connects with a particular contract, it's Article 7.1, but otherwise it falls within Article 7.2. And you can see that towards the end. And for good measure, Professor Hartley...
Just before we leave this,
of course.
It might be thought significant at the foot of 1142 that he distinguishes situations where the restitution is simply the logical consequence of proceedings in a matter relating to a contract.
Yes.
So that are no more than the remedial consequence of proceedings which were in a matter of contractual obligation. Now here, the restitution is conditional on the setting aside of the settlement agreement, isn't it?
Well,
where your case is put.
No, it's not insofar as it is. There are two grounds of restitution. One is restitution upon avoidance of the settlement agreement.
Yes.
There's also a separate restitutionary claim on the grounds of mistake, bearing in mind the bank. So insofar as the bank is not a party to the settlement agreement, as the court below has held.
Sorry, is there something you want to...
No, that's fine.
Oh, I'm so sorry.
No, thank you.
He was thinking that you had a further question.
No, I'm sorry.
So now Professor Hartley comes to the same conclusion as Professor Briggs, and you can see that at OA3, tab 76, page 1957. If I give you references, basically it's the same thing. It's paragraphs 825 and 826 on 1957. And then at 1959, page 1959, it's paragraphs 8135 to 8140. It's probably worth also referring the court to the decision of the European Court in Ergo Insurance, which is at PA2, tab 23, page 909. Paragraph 43 to 46. Now, this touches on the point which Professor Briggs made about ensuring consistency between the Rome regulations on the one hand and the Brussels regulation on the other hand. And you can see at paragraph 43 in the second sentence, which is about 5 lines down, the court says, as is clear from recital 7 in the preamble to each of these regulations, account should be taken not only of the aim of consistency in the reciprocal application of those regulations, but also in the application of the Brussels I regulation, which inter alia draws as a distinction in Article 5 between matters relating to contract and matters related to tort, delict, and quasi-delict. And just, of course, Article 5 is our Article 7 now. And then if paragraph 45, so we skip a paragraph, the court says, as regards the concept of non-contractual obligation within the meaning of Article 1 of the Rome II regulation, it must be recalled that the concept of matters relating to tort, delict, and quasi-delict within the meaning of Article 5.3, which is our Article 7.2, includes all actions which seek to establish the liability of the defendant and are not related to a contract within the meaning of Article 5.1. So here we have a clear expression by the European Court of the notion that Rome II regulation, which applies to non-contractual obligations, both tort and unjust enrichment, should be interpreted in line with this notion of Article 7.2 or Article 5.3 in the judgment, referred to in paragraph 5. So, with that introduction, the question is, why should this court overturn, or insofar as it's inconsistent with my case, the decision of the House of Lords in Kleinwort-Benson? And if it helps, I can take my lady and my lords to the judgment. They're very short segments. I can give you the page references if it assists as well. I'm in your hands. What would you prefer?
Well, give us the page references
Okay,
and
well,
then tell us what you say.
Okay, so the page, just for your reference, the page references are 674 of the electronic bundle, sorry, it's PA1 tab 7, 674, 679, 687, and 698. And essentially Lord Gough and Lord Nichols and Lord Hutton, basically led by Lord Gough, I would with respect say, it says that the reason why it doesn't include unjust enrichment is because unjust enrichment very frequently doesn't include a harmful event. Now, the answer to that is, firstly, in this case, there is a harmful event. Secondly, many claims for unjust enrichment do involve a harmful event. And thirdly, insofar as we're concerned with claims for unjust enrichment and we have to identify a harmful event, it's very easy to do so by reference to the failure of the defendant to pay restitution.
Hmm.
Now, I also would suggest that Lord Gough puts too much emphasis on how one categorizes unjust enrichment claims according to national legal systems. He doesn't say that in terms, but it seems to me when he makes, his lordship makes his comment about this, he's clearly having English law in mind. And the difficulty, of course, is the problems of categorization of how one identifies various obligations, whether in tort or unjust enrichment across various legal systems. And you can avoid all that altogether if you adopt what I could describe as the literal interpretation or the literal meaning interpreted by the European Court in Calfellis, which has been repeatedly applied in numerous decisions since then. The other point I would make is Lord Clyde does suggest some sort of mistranslation, but I think he's concerning with the other issues also identified in the Calfellis decision. But based on that, you can see also from the judgment this is given very short shrift in the judgment itself. There's not much said by the House of Lords on this particular issue. Each of the law lords deal with it in a paragraph. And therefore, there's no real consideration of the various factors which I've identified before this court. So for those reasons, I would say that restitutionary claims should come within Article 7.2, in which case there would be jurisdiction subject to the issues which will be argued tomorrow. And secondly, that insofar as the decision of the House of Lords in Kleinwort-Benson is inconsistent with that, it should be overturned or reversed. They're my submissions, unless I can help you further.
It would appear not. Thank you very much indeed.
Thank you.
Ms. Healy?
Nothing to add.
Thank you. Yes. Mr. Bailey.
Thank you, my lady. On issue 1, then, taking the same order as my learned friend, Can I just say two brief things about the facts on which this issue proceeds? You will see from the statement of facts and also the judgments that the vessel sank on the 3rd of April 2013, and 2 days after, my client wrote the letter of authorization that my learned friend showed you at core 2 7K417. But what happened thereafter, there may be an element of difference between my learned friend and I. In our submission, what happened thereafter, according to the finding of the Court of Appeal, was that the owner made a claim on the insurer on its own behalf and not on the bank's behalf. And therefore, on that finding in the Court of Appeal, which may or may not be different from the judge, but that is the finding that we rely on, there was no presentation of a claim and no presentation of the letter of authority by the owner on behalf of my client, the bank. And can I just indicate to you, perhaps I'd like to show you the parts of the Court of Appeal judgment to make that good. That's in CV2, tab 7B. The judgment starts at page 321 in the electronic bundle. And I wish to go to page, I beg your pardon.
321 is Mr. Justice Tier's judgment, is it not?
My learned friend relied on Mr. Justice Tier's judgment,
Yeah.
and I'm relying on the Court of Appeal to the extent that they upheld him.
My observation was that Mr. Justice Tier's judgment is at 321. If you want to refer to the Court of Appeal's judgment, I think it's a different judgment.
Yes, and there was a difference here. 278 is where the judgment, the Court of Appeal starts in the electronic bundle, but 288 is where I would invite you to look. And this is in a section that starts at 287 under the settlement agreement. And in particular, paragraph 39 at 288 of the electronic bundle, the Court of Appeal, this is Lord Justice Gross, but speaking for all three, he says at 39, quoted the judge, the bank, if it had wished to do so, could have instructed the owners to make a claim on the policy on its behalf. It was an equitable assignee and so on. There was, however, no direct evidence that it had done so. To the contrary, Mr. Tafun's evidence was that the owner would deal directly with underwriters on their own behalf. Now, that is the Court of Appeal speaking, and then later on at page 289 in paragraph 40, they consider paragraph 32 of the judge's judgment. Now, that's not one that my friend cited, but it is the one that the Court of Appeal upheld. And at page 289, they refer, I won't read it all in paragraph 40, but at the end, just above the 41, instead, says the Court of Appeal, at 34, the terms of the letter of authority and its context were consistent with the bank's understanding that the owners would deal with the hull underwriters on their own behalf, but being concerned to ensure that the sums received by the owners from the policy would be used to discharge the owners' debts to the bank. And, my Lord, the actual finding of the Court of Appeal is at page 292 to 293 of the bundle. Again, I won't read that all, but I would wish to draw your attention particularly to a passage at 293 of the electronic bundle within paragraph 51, subparagraph 2, where the court refers to paragraph 33, and perhaps 2/3 of the way down that subparagraph 2, almost exactly in the middle of the page, just below perhaps the first hole, the judge's conclusion that there was not a good arguable case that it had done so, meaning made the settlement agreement on its behalf, was consistent with the letter of authority and the evidence as a whole, namely that the owners would deal with the underwriters on their own behalf, the bank's concern being confined to the use of the proceeds once received, and that's approved. So the Court of Appeal finding is that the bank dealt the owner dealt with the insurer on its own behalf, did not make the claim and did not present the letter of authority on behalf of my client. And I say that because my learned friend in his skeleton argument, his case, at paragraph 41, subparagraph 2, and he repeated this orally, the reference is the core bundle 1, tab 6, page 176, makes this submission, which is actually important when one comes to the application and the resolution, and it's wrong in our submission. His submission 41.2 is, the letter of authority was presented to the insurers on behalf of the bank. Now his footnote 35 reads, while the means by which the letter of authority was presented is not in evidence, it is indisputable that it was so presented, as it is common ground that letter was signed by the bank. Well, it is common ground that letter was signed by the bank, but it is not common ground that it was presented on behalf of the bank, and the Court of Appeal found the contrary in my submission.
And what about attached to the settlement agreement? Is that common?
That's correct, yes. That, my lord, is in the context that the settlement agreement was made by the bank, by the owner on its own behalf. Your lordship can see the attachment situation in CV2, page 412 is the settlement agreement, and the attachment is 417. In this instance, it doesn't always happen, but in this instance, the bundle replicates the original state of the document.
And so the letter of authority was, although addressed to the underwriters, was given to the owners?
That is the right inference, yes. And then presented on their own behalf in order to get a payment to Willis. And the point was, and it's in the evidence, but the point was that of the 22 million Hull proceeds, only about 15 or about 17, I can't remember the details, were used to pay off the bank, and the remainder was retained by the owner for his own account, because the amount of debt outstanding on this particular vessel was 15, whereas it was insured for 22. So on the facts, the owner made its own claim on its own behalf. It went to Willis, which is the owner's broker, and then it went from Willis to my client in Malta. And of course, when considering unjust enrichment and a receipt-based claim, the event, not a harmful event, but the event of receipt could be arguably is in Malta, but that's not a measure. Anyway, our submission is basically that on the first point, the unanimous decision of the Court of Appeal and the decision of the judge, as reflected in the Court of Appeal judgment at paragraphs 57 to 59, is unassailable because of the basic principle that an assignment does not transfer the burden of a jurisdiction clause, but only the benefit. And the true principle in English law, to the extent that it applies, is that if the benefit is conditional, has a condition attached, then the assignee cannot enforce the benefit without complying with the condition. But here, the condition attached is the jurisdiction clause, and the condition, therefore, is that my client cannot enforce the insurance claim without acknowledging the jurisdiction clause, but it didn't. It did not breach the jurisdiction clause. Even if the letter of authority is to be read as, please now pay the claim, that is not a breach or a violation or an inconsistency with the jurisdiction clause, because the condition contained in the jurisdiction clause for relevant purposes is only that thou shalt not sue except in accordance with the clause. And that is the fundamental problem with my learned friends' entire submissions. Now, I'll come back to that at the end, and that's the answer, and a brave advocate would probably stop here. But I, however, will go on and answer my Lord Reed's question of the extent to which this is an EU or a domestic law question. And the answer is it is both, because in our submission, the EU rule that applies as to being bound by a jurisdiction clause is, as is well known, a test that there must be actual consensus clearly and precisely demonstrated. And that is an autonomous EU principle, and that is the test that this court is bidden to apply. And English law comes in only at the second stage because there is what I might call an exception or a preliminary reference back to the national law, the context of which is that national law is relevant only if it provides, and to the extent that it provides, the third-party assignee succeeds to the obligations of the assignor. So English law comes in only at the stage to see whether there is an EU law succession in that sense. Can I make that good, and that will take me up to a convenient moment, firstly by reference to the first proposition is that a beneficiary of insurance is not bound by a clause, a jurisdiction clause in the policy, and that is the case of Société Pelou, Primary Authorities Bundle 2, tab 30, page 1030 of the electronic bundle, which is the start of it. But I would invite you to look at page 1051 of the electronic bundle. We will have to come back to Pelou in other contexts.
1051, did you say?
1051, paragraph 43 of the Court of Justice of the European Union's judgment. And the answer is a jurisdiction clause conforming with Article 12.3 of the Brussels Convention cannot be relied on, and that's the insurance section, which is now 15, cannot be relied on against a beneficiary under that contract who has not expressly subscribed to that clause and is domiciled in a contracting state other than the policyholder or the insured. So that is the basic European rule, but the permitted exception, if I can put it that way, is demonstrated by the case of the Tilly-Russ, which is a case of a bill of lading. Now, the interesting thing about English law of bill of lading is that when the bill of lading is transferred, and provided other conditions are satisfied with, there is transferred with the bill of lading to the receiver rights and obligations, rights and liabilities. So that's the context of that. But for the present purposes, the principle of the Tilly-Russ, if I can invite you to Principal Authorities 2, tab 31 at page 1069. Which is paragraph 26 of the judgment, and this is the answer, and this is the source of my answer to my Lord Reed as to the, as it were, demarcation line between EU law and national law. Paragraph 26 at 1069, after reciting the matter and referring to Article 17, now 25 of the Convention, in the case of a jurisdiction clause contained in a bill of lading, provided the clause has been adjudged valid between the carrier and shipper, and provided that by virtue of the relevant national law, the third party, upon acquiring the bill of lading, succeeded to the shipper's rights and obligations. Now, in English law, it does, but that's the test. Does the national law effect a succession of obligations? That was repeated and affirmed in the case of Correc, which I won't take time up with now, but it's Other Authorities Bundle 2 at page 1702, paragraph 27 of the judgment.
Sorry, the reference again, please.
Yeah, sorry. other authorities 2, page 1702, paragraph 27. Correct against handle something quite long, but meaning ship-owning company. So English law only is relevant to the extent that it creates succession, and whatever other of my learned friends' submissions you might be inclined to accept, and I'll be submitting not many, the English law does not affect that relevant form of succession. One is back to the basic EU rule, clear consent, clearly expressed, I paraphrase, and it doesn't satisfy that. I don't know if that's suitable, my lady.
It's about a minute over, but never mind.
I apologise.
We will attempt to be back at 2 o'clock to hear your further submissions. Court will now adjourn.